How's it going, guys? Andre Issa here, your friendly neighborhood employment lawyer, and today we're going to be talking about constructive dismissals. Have you ever experienced a substantial change to your employment contract? Like, for example, your boss decides to demote you and cut your pay, and you go, wait a minute, that was never in my employment contract. Is my employer allowed to do that? Well, if that is the question that you have, you're in luck, because this is the exact video for you. We're going to be breaking down exactly what a constructive dismissal is, what are some examples of constructive dismissals, and if you do believe that you've been constructively dismissed, what exactly should you be doing? But guys, before I dive into it, I just want to put a brief legal disclaimer out there. As always, what I'm about to say does not constitute legal advice, it's just legal information. If you believe that you've been constructively dismissed, you're welcome to contact me or any other employment lawyer in Ontario. Okay, so with that disclaimer out of the way, let's jump right into it. So I wanted to start off by defining what a constructive dismissal is, according to the Supreme Court of Canada in the case of Farber and Royal Trust Co., where an employer unilaterally makes a fundamental or substantial change to an employee's contract of employment, a change that violates the contract's terms, the employer is committing a fundamental breach of the contract that results in its termination and entitles the employee to consider himself or herself constructively dismissed. So from that legal definition, we can draw a few things. Essentially, what that definition states is that a constructive dismissal is a fundamental change to your employment contract. It is so fundamental, your employer is doing something that is so different from what you agreed to in your employment contract that it essentially amounts to you being terminated or fired from your employment contract without your boss actually ever telling you that you've been dismissed. Law instead constructs a dismissal based on the surrounding facts of your case. It's important to note, however, that the law has since evolved since that decision. There was a 2015 decision by the name of Potter and New Brunswick Legal Aid Services Commission, where the Supreme Court of Canada recognized that there are in fact two types of constructive dismissals. The first one is a constructive dismissal based on employer behavior that may not breach a term of the contract, but that makes continued employment intolerable. And two, the second type of constructive dismissal is based on a substantial breach of an essential term of the contract. So the second one sounds awfully familiar to the case of Farber, where there needs to be a substantial change of the employment contract or a substantial breach of the employment contract. However, the court also recognizes that a constructive dismissal can be created if continuing to work at your workplace would be intolerable due to employer conduct. If you're still confused, that's okay. I want you to imagine that this is an employment contract. What I've just done there is committed a minor breach of the employment contract. It didn't tear the entire employment contract altogether, but it was a minor breach of the employment contract. This may not be enough to amount to a constructive dismissal, even though there is a minor breach of the employment contract. What the law suggests is that in order to amount to a constructive dismissal, there not only needs to be a breach per se, but there has to be a substantial breach to the point where the employment contract has been terminated. So that's essentially what a constructive dismissal is. Now I'm going to give some examples. Colistro, an employee, had worked for the employer for 20 years. In 2007, the employer decides to hire Benoit as vice president. When Colistro found this out, she was shocked because in the 90s, Benoit had been terminated from the company for sexually harassing her along with others in the company. She then went on sick leave and was diagnosed with PTSD. She demanded that the employer not hire Benoit. The employer refused and went ahead with Benoit's hiring. However, the employer did offer to transfer Colistro to another building where she could feel more comfortable. Colistro refused to be transferred and instead decided to quit and sued for constructive dismissal. The question for the court was, did the hiring of Benoit make Colistro's continued employment intolerable and therefore amount to a constructive dismissal? And the answer, according to the court, was yes. The court ruled that the employer's behavior made continued employment intolerable for the employee. The test is whether a reasonable employee in the employee's situation would find that the employer's behavior made the workplace intolerable. The employer's behavior can take the form of a series of harmful actions or a single serious act by the employer. In this case, a reasonable employee would find that the employer's decision to hire a man who had earlier been terminated for harassing her, knowing that this caused her trauma, would render continued employment intolerable. Therefore, the employer had constructively dismissed Colistro. As a result of this, the employer was ordered to pay 12 months worth of reasonable notice plus additional damages of $100,000 for bad faith in the manner of dismissal. So let's break that case down, guys. The employer had to pay over 6 figures in damages to the employee because they had constructively dismissed her by rehiring Benoit as VP, even though he had a history of sexually harassing her along with other employees at the office. The reason why that amounted to a constructive dismissal, according to the courts, was that continued employment there would have been intolerable for her, and that amounts to a constructive dismissal. Alternatively, what the employee could have argued, of course, was that there was a breach of a substantial term of the employment contract, that term being the implied term of civility, dignity, and respect, which is in every employee's employment contract in Ontario. You have the right to a workplace where you are not sexually harassed by your coworkers, especially not your superiors. And if that does happen, then that may constitute a constructive dismissal, and you may be entitled to money because of that. So that's an example of what does amount to a constructive dismissal. But remember what I said. A constructive dismissal has to be a substantial change to your employment contract. Well, what are some examples that don't amount to a substantial change? Ones that are minor breaches or minor changes, but aren't enough to amount to a constructive dismissal. In the case of Pullen and John C. Preston Limited, the court found that a cut in the employee's base pay of 10%, while it may have constituted a minor breach, because nowhere in the employment contract did it say that the employer can cut the employee's pay by 10%. However, overall, it was a minor breach and therefore did not amount to a constructive dismissal. Because remember, the theme of this video is that a constructive dismissal has to amount to a substantial breach of your employment contract. Minor breaches are not enough to amount to a constructive dismissal. They have to be substantial, major, fundamental changes to your employment contract. So, you might be wondering, what exactly is the key takeaway here? Well, what you do if you believe that you've been constructively dismissed is you contact an employment lawyer like me. And what I would do is I review the facts of your case and I determine, number one, is what occurred a breach of your employment contract? Number two, is it a substantial breach of your employment contract? Number three, how long has it been since that substantial breach occurred? The longer you wait, if there's been a substantial change to your employment contract, the more you risk losing a case for constructive dismissal. That's what the case law says, and that's why it's so important to contact an employment lawyer immediately, ASAP, if you believe that your employer is committing a substantial breach to your employment. The longer you wait, the more you risk losing a case for constructive dismissal. So the moral of the story is, contact an employment lawyer today if you believe that you may have been constructively dismissed. This has been Andre Issa, your friendly neighborhood employment lawyer. Until next time, guys.